Okay, I have 2 o'clock, so we will get started. I want to welcome everybody today to this webinar. We're going to discuss ERISA documentation requirements for employers who sponsor group health plans, and I'd like to thank BIS Benefits for inviting me to present this webinar to their friends and clients, and hopefully we'll help you weed through some of the um, concerns you have about where your plan is with regards to compliance and offer you some solutions on how to move forward if you are in any spots where you feel like you're not compliant. So we'll go ahead and get started. I will say this format does not lend itself very well to questions, but there is a question feature to this GoToWebinar mechanism, and you can type in your questions. It's hard for me to review them on the fly, but what I'll do is when we get finished, I will go through them and try to address them. And if I can do it succinctly in the webinar format, I will. And if not, what I'll do is try to respond individually to the questions if that's a better way to go, because I can record them and I have who asked them. So we'll do our best to get all the questions answered, of course. So we'll go forward. I am a member of the State Bar of Georgia, so one of the things I need to do is share my legal disclaimer. None of the information provided here today is intended to be legal advice, but it's general information. So if you need specific advice about your situation, you should consult a qualified legal consultant. Here is my bio information. I graduated from law school. And so my specialty is federal compliance issues like ERISA and healthcare reform and HIPAA and COBRA. And so there's just a little bit more information about me. One thing I will say is I will be able to send everybody a copy of this handout, some sort of self-check on your own plan. So I err on the side of giving you too much information. So I apologize in advance for the density of the slides, but you don't need to take a lot of notes because I'll be happy to provide you with the slides when we're done here today. So what I want to cover here today is basically the basics of ERISA. What does ERISA require? Where does it come from? And what happens if we don't do what we're supposed to? Different categories of ERISA requirements. Some other laws we should consider. So what is ERISA? Well, it's a fairly old Employee Retirement Income Security Act of 1970 benefits so that you don't have to deal with plans because insured plans still to a large degree remain governed by rules. Don't have to worry about differences from state to state. ERISA statutory penalties and also significant litigation. Obviously go through those in buddy. There's really 3 categories of employers that are exempt from ERISA. Governments are exempt, church plans are exempt, and Indian tribal plans, which for those of us here in Georgia, that's not a really big deal. A couple comments about these. Most government plans obviously are happy to be exempt from ERISA, but even so, they still will follow a lot of the ERISA rules, for example, with regards to appeals, because they need some structure to govern the plans that they offer. But there's certain things, for example, Form 5500s, that they can opt out of because they're not subject to ERISA. Church plan, those of you who work with church organizations, for example, church-affiliated schools may not be that with a client. I usually redirect them back to their own attorneys basis, but a true church is exempt from our subject to ERISA. And so is everybody else. Now I'm going to warn you when I talk about the types of exceptions, which will narrow this out to a degree. So I'm going to make some statements about what's subject to ERISA that are fairly knowledgeable on the subject may say, well, that's not true, or oh, I hope that's not true. And you might well be right, but I'll kind of start broad and narrow it down. So the way ERISA defines a benefit that's subject to its welfare benefit rules are a benefit that is some sort of plan established or maintained listed in ERISA that can be covered under ERISA are pretty inclusive. They're medical, surgical, and hospital services, holiday and severance benefits, which we don't typically associate with ERISA, and housing assistance benefits. And you can see from the asterisks that I'm kind of really prepping you for these exceptions that we're going to talk about in just a second, but often are not due to one of the exceptions. And I probably should have had an asterisk next to unemployment benefits as well. Of exceptions to exempt benefits that are create a special fund to pay out vacation pay. Most small employers don't do things like that, but some large employers do. There's some other regulatory exemptions, things like holiday gifts and remembrance funds for maybe family members of our deceased family members of our employees, where we might buy them flowers, things like that. Even though they're considered quote-unquote benefits, they are. And then the last is a very important ancillary insurance hospitalization or other subject to ERISA. So sometimes employers will go an extra step to make sure that we don't have to deal with ERISA with these types of ancillary plans. So once we determine which of our benefits are subject to ERISA, there's really fiduciary duties, which is probably the most important. It's just something we don't see very much of in the world. So the written plan document requirement, I'm going to go over a few things. One is simply the requirement that the document is in writing. We're going to talk a little bit about the format and structure that's required of plan documents, which is actually very minimal. We're going to go through some required provisions in your plan document, and we're going to go through some recommended provisions. I just have a note here that because people ask sometimes, is it be in writing? And the answer is yes. It's a statutory provision of ERISA. But I will add that if you don't have a plan document, it doesn't mean that you don't have a plan. I've had some employers say to me before, well, one of the reasons we don't want to have a plan document is that way we can't get in trouble for not doing what we're supposed to do because we don't really even have a plan, and that doesn't hold up. There's plenty of court cases where a court has come behind an employer and we're going to tell you what it says, and that's really the danger of not having a plan document. So having established that you must have a little bit of guidance expressly on what must be in it, but really the question comes up in the marketplace so much, well, about our health insurance document. The problem with them is, so one of the reasons that we're so adamant about recommending that clients we work with get up-to-date and current and fully compliant plan documents. One question we get is, can the plan document and the other serve two different purposes? And here's where the conflict comes into play. A plan document is frankly that most employees don't understand. And so the legalese of a plan document may not satisfy the requirement of a summary plan description with regards to clarity and understandability. So there's a little bit of an art there. Not to say that you can't use the same for both. And in fact, when we prepare documents, we try to make them the same to the extent we can. But there is an art there to doing that properly. So among the required documentation does not address. Another important provision, administrator have other parties do, or allocate payment of claims to somebody else. That information could be wrapped in an insurance document, or it may not. The funding policy for the plan, again, very important, because whether a plan is funded or is unfunded may or may not determine if a Form 5500 must be filed by the plan. So specifying that out clearly can prevent the employer from having to file a 5500 possibly. How payments are made to and from the plan. This information is often paid, what gets paid for, but it may not talk about what elements that must be in a plan document, and is very rarely itself. Any attempts to could be rejected or denied or altered. So plans really need to do a good job reserving the ability to amend themselves, and they do that in a plan document. And then lastly, ERISA requires plans to specify what happens to any assets that the plan is holding if the plan terminates. It has to have rules regarding COBRA and USERA. USERA and HIPAA privacy and security information, how to personal health, protected health information. A notice about minimum stays after childbirth. QMCSO rules, which stands for Qualified Medical Child Support, and other federal mandates are required to be in the documents according to ERISA. Now, a lot of these also will be in the fully insured group health plan, but sometimes they're not, and you have to evaluate your documents to determine compliance there. And then here's some recommended provision, and there's no law to pay somebody else without notifying them. If there's a long-term disability claim and is entitled by their contract to get reimbursed out of the value of that judgment that the victim wins in court, you cannot enforce a subrogation provision against a participant unless you've notified them of that provision and what they have to do with that as part of their lawsuit. So the employer could end up paying the long-term disability insurance company instead of having that money legal settlement or legal judgment. A couple other provisions that are really important are naming which state law will govern the plan. If you operate that they're not guaranteeing going to be tax-free, but they weren't, related to the fiduciary responsibility, which I've said a couple times is really the most dangerous or important function that comes with an ERISA plan. And for example, the fiduciary functions could give the individual the ability to serve in more than one fiduciary capacity without necessarily creating a conflict of interest. It could give the fiduciary the ability to employ other people to help them with their deal within the plan documents, particularly if they're not dealt. Somebody has to work issue. So these are all issues that it's helpful to have addressed inside of a plan document. And then it's very important to make sure that the plan document actually jives with what the employer is actually doing with eligibility, that what the employees are being told fits with the eligibility provisions of the plan document. With regards to benefits, ERISA is also very loose, and this is one of the reasons. But once you promise benefits inside as they see fit, but if they do that, they need to follow the administrative requirements that they set. For example, they might require employees to fill out a specific form in order to get reimbursed from a health FSA, rather than just sending in a receipt. But if they do that, they need to stick to it for all the employees and not allow highly compensated employees, for example, to just send in their receipts, but require the rank and file employees to fill out a special form. Plan documents trust, and there's some tax reasons why employee, the responsibilities of the plan administrator escalate dramatically once there are contributions from plan participants. Now, there are some exceptions which, for example, if there are plan contributions paid through a cafeteria plan, a premium-only plan, the employer is not required to get a bond for that money. But if, for example, it was a self-funded disability program, that money would have to be bonded. So that gets a little bit beyond the scope of what we're talking about today. For example, to pay expenses. If there, for example, if there were four, I mentioned before the importance of plan document amendment and termination language. Without adequate plan amendment authorization in a document, the plan sponsor may be a little handcuffed in their ability to make changes. Now, it doesn't mean that the plan sponsor needs to be too careful. If it was a document, I give the plan sponsor as much absolute and unconditional authority as I can. I claim as much authority as the law will give to my employer clients. Plan benefits that are vested and protected, that most part employers can be probably the highest one in the law. There's different standards of behavior. One is, for example, just don't be negative, do things on purpose. Well, this one is a high standard. It's basically the common expert standard. And so what it means is that like a fiduciary in the same situation. So it's basically being a fiduciary. One thing I worry about for liability, which can be very risky. So to the beneficiaries, you can't be looking out specifically for the employer in those cases. You must do your duties for the exclusive purpose of providing plan benefits. And I mentioned the standard of care there, out of the diligence that a prudent person acting in a like capacity would use. And so it's just a high standard. So I just want to warn people about that. So that's the plan document. So then we have some other disclosure requirements. We have summary plan descriptions. We have summaries of material modifications. We have summary annual reports. And we have responses to participant requests. And the last one of these is the one of the relevant information in here as I could. So ERISA requires almost it's up to the plan administrator to actually distribute that. If there have been material changes in the plan, you have to give every participant a new summary plan description every 5 years. And even if there hasn't been a single change to the plan in 10 years, which is kind of impossible, I realize, but even if that was true, you have to give every participant a new summary plan description every 10 years. Now you can deliver the summary plan description via the U.S. mail, via hand delivery, or electronically, but if you're going to do it electronically, it is subject to the Department of Treasury's electronic media rules, which basically say that in order to distribute something to somebody electronic, just like ShareFile, and then I could demonstrate that they actually of your employee base that only speaks 20%. If 20% of your employees only speak Spanish, or I should say 20% of your participants, you would have to get your SPD translated into Spanish. But one of the tricks I have as an HR person is I ask all of my hires English. Now, it's not a condition of being hired. It's a condition of how I have to provide them the documents. So I just ask them, can you speak English, yes or no? Language. So then I don't have to worry about converting my SPDs into Spanish. And I've 502 child care center plan, for example, the eligibility provisions, a description of benefits, claims and appeals information, subrogation and coordination of benefits, which I mentioned before in conjunction with the long-term care plans or long-term disability plans. And then very important, a statement of ERISA rights, which is the language of that's dictated by the Department of Labor. So that should be in every summary plan description. One thing that gets overlooked all the time is the provision of summaries of material modifications for November 1st. Now, having said that, although you don't have to provide the summary of material modifications right away, you have a different requirement for summaries of benefits and coverage. So I know that can be very confusing, but the summary of material modifications goes beyond group health plans. So if you change, for example, a severance pay package program, you have to provide a summary of material modifications within the time frame listed on this slide. And what a material modification is not described very well by ERISA, but one thing that it always is if you have to change language in something that's recordability, I also believe that's always a material. The summary annual report is a narrative of plans form 5500. So documentation disclosure is responses to participant requests. If a participant makes a written request to the plan administrator who's listed in the summary plan description, they must receive 30 days. If there's no response within 30 days, the penalty is $110 per day is in litigation. Beneficiary, and there may not be a plan document, or it may not be a complete plan document. So what it does do is give the attorney in that litigation in complete fashion. I get asked all the time, hey, can we charge them for documents? You can charge them the actual cost of providing. But for example, if you have a copier contract where you only pay yourself 2 cents per page for copies, then that's all you can charge. You can't gouge them for additional expenses. So again, just very important. And one of the underlying things on this is, in order for them to make a valid request, there has to be a plan administrator. If the plan document doesn't name the plan administrator, they can make the request of it. Yet another importance of naming a plan administrator in a plan document, and responses to DOL for requests unless, which generally means under 100 participants on the first day of the plan year. And if the plan is over 100 participants, they file a 5500 no matter how it's funded. So another thing to keep in mind is if you wrap several benefits together, for example, you only have 60 people in your health insurance plan, but you have 110 people in the group term life insurance program that is provided for all of your employees, and you wrap the life insurance and the health insurance and the life insurance. Very good about filing 5500s. 500 are due each year. At the end of the 7th extension, you could file as late as October 15th. They are all filed electronically now. We used to file 5500s on paper, but the only way the government accepts them these days is through a electronic software program. So typically, in order to file one, you either have to buy the software program or hire somebody who does 5500s. And here's the real problem with 5500 noncompliance. The penalty for noncompliance is $1,000 per day. It is not capped, and it is not, and it is, I should say, it applies for every plan year. So that's obviously a number that could put companies out of business quickly. But the good news is there's what's called the delinquent. It encourages employers who are behind in their filings to come forward and make their filings, and when they make their filing, to pay a one-time penalty that is, in fact, the largest penalty that you would have to pay per plan is $4,000 in total. So if you were 10 years behind, and this was for a wrap plan with all your benefits in it, you could get away with paying a $4,000. Say, well, I'll never be able to get out from underneath. And the Delinquent Filer Voluntary Compliance Program is a very effective way for employers to kind of come out off of their plate. There's several Schedule A's, or schedules I should say, that go with the Form 50. Provides information about the insurance plan, if it is an insured plan. And that typically deals with who got paid commission on the plans, if anybody, and also some information about the experience of the insurance, things like that. That information is provided by the insurance company. If you have more than 100% participants, it almost always comes automatically. But if you have less than 100, you often have to go to the insurance company and ask for the information. And then to describe to the Department of Labor anybody on the scope of what we're talking about today, but just be aware, for example, a Schedule H, which deals with financial status of the plan, particularly applicable to large self-funded plans. And then nasty, the ones I've seen, and it's very concerning to employers with the DOL auditors. First of all, they are will probably raise their concern level, and it may actually cause them to poke around into other areas you don't want them poking around in. For example, your 1099 compliance or your wage and hour overtime compliance thing. And there's some things you naturally just won't have. They may not even apply at all to your plan, and it's okay to see here. Typically, they're the result of an employee complaint, or they're the result of other problems within the company that are discovered. For example, wage and hour problems or 1099 misclassifications. Once the DOL gets into a company, they do tend to look for other issues. So that's when they might ask for more on the welfare benefit plan. So when we talk about DOL compliance, I don't want to come across as, hey, if you don't get your plan document in place, you're doomed. You're going to get a terrible fine and lose your company. You do get a request from the DOL for the information. You do need to be quick to respond. Record keeping for 6 years requirement. So in the end, because of when this 6 years falls, I would recommend keeping documentation related to employee contributions, individual eligibility plans for 8 years from the date they're generated. You can keep them electronically. There's no problem with that. You just need to be able to produce them in the event of an IRS audit, but that's the window that they might request in an audit. And so let's talk real quick about the consequences of failing. Just important things about not having a plan document, if they're spelled out for appeals, is what's called abuse of discretion, which basically, if you don't have a set of, give what's called de novo review, meaning they pretty much do what's fair, or they'll do what they think is best. And that may or may not be what you intended in any way, shape, or form. So you don't want that kind of standard, because you might get a judge who thinks the fairest thing to do is to pay somebody's disability claim for the rest of their life. But if you have a plan document that clearly says we pay disability for 13 weeks, that's what you're going to get. HR professional. So what if as an HR professional you miscommunicated some plan terms to a participant? You said that anything wrong at all, but a participant convinces a plan document and frankly that summary plan description to set plan on your terms when you want to, rather than have it being hamstrung with that. ERISA does in fact build in some criminal penalties, possibly for willful failures. These most typically deal with failures in that fiduciary duty that I mentioned before. And again, this is why it's so important. If as a fiduciary you steal money from a plan, you can go to jail. So I don't mean to frighten folks by thinking if you don't have a plan document, you're going to jail. I'm not saying that in any way, shape, or form. The criminal kind of focused on intentional. Department of Labor can take you to federal court to make you provide a plan document to them. And then again, a plan amendment or termination could be, what does ERISA require? But you also always have to ask, what do other federal laws require you to do? So I just wanted to highlight a couple here just to put them on your radar. The Affordable Care Act, we've mentioned the summaries of benefits and coverage. And keep in mind, if you're going to change a benefit in the middle of a plan year, you have to give participants 60 days notice in order to do that in advance. So that can mess with your planning. So make sure you're up to date on your summaries of benefits and coverage. Hopefully everybody's up to speed on the 1094 and 1095 reporting that goes into effect this January. It's one of the topics I've been speaking all since. And if Labor came out and said there's no penalty for not doing it that we need to provide to our participants. There's no insurance company will take care of that. And then notice of FMLA procedures if you're large enough to be subject to FMLA. And then lastly, I just have a couple recommendations here if you're considering some sort of self-audit. I think it's important for every company to think about all of their welfare benefit programs and then try to match those programs up with their documentation. Do you have complete plan documentation for your concerns about the operation of the plan? Are plan assets being used appropriately? Are perhaps, for example, MLR refunds, if there are any, be your documents or your operating procedures? So that's pretty much all I have on the ERISA side. So, one of the things that BIS Benefits asked us to do is we don't have to go through that in the presentation today, but I would invite anybody on the call to either contact their BIS benefits professional, or you can contact me directly for more information about any concerns you have about any of these ERISA compliance issues. We have what I think is an excellent product called EverWrap that combines pretty much everything that we can find that small employers and medium-sized employers need to communicate to their employees, and try to put it in one nice, concise as we can be package that's readable and informative for employees. So we'd love to get you all more information about that if that's something that's interesting to you. Beyond that, let me see what question. Our forms are forms that employers that are either subject to the Affordable Care Act's employer mandates, employees in January, about the coverages that they offer and the coverages that folks are enrolled in. And they'll also file them. But I would be happy to answer more individual questions about that if that's something that you have concern about, or to see if it applies to you. So I'll follow up with that individual who asked that question. And let me see if I can get to the other questions. The way this scrolls, it's kind of hard. I did have a question about if the business has less than 100 participants, what requirements are you subject to? If not, Form 5500. All of these ERISA requirements, other than the 5500, go down to 2 life groups. So the documentation is the critical piece there. And I'm sorry, but in the way the formatting is, I cannot see the other questions, but I will review them and I will follow up with the question askers. At this point, if there's anything else that anybody want to type it in the chat real quick, you can, and I'll address that. Otherwise, I thank you so much for your attendance today, and out to all the attendees. Thank you so much.